Hello and good evening, everybody. It's me, Brian Burke, from Shehab Burke, based here in the fabulous Columbus, Ohio area, but more specifically, as I can see it out in front of me, the city of Dublin, Ohio, where we are based. It is Monday. It is 6 o'clock p.m. That means I am here to talk to you guys about interesting immigration issues that I want to talk about. And boy, is it going to be a good week. What we have here is a Visa Bulletin week, a late breaking Visa Bulletin week, which, for those of you who can see it, I've updated our topic to reflect that we are going to be talking about the Visa Bulletin today. It's an interesting one, way more interesting than I expected, a real exciting one. So we're going to talk about the Visa Bulletin. On the back half, we are going to talk about just some fun and interesting trends that we've seen in H-1B visa stamping, because that is something that I think is of interest to everybody in our audience. So, thanks for tuning in. Strap in and get ready for it. So, big picture, big item number one. Precursor to that, I'm here by myself this week. My partner and friend Sam Shehab is traveling today, but he will be back next week. But so no worries about that. But bottom line is, we have a great topic to talk about in the terms of the July Visa Bulletin. And I'm going to put that July Visa Bulletin up here on the screen so you guys can see it, because if it's not apparent by the look on my face, I'm pretty excited about it. And here it comes. There it is, Visa Bulletin for July 2024. And there were some things that were predicted and expected on this Visa Bulletin, but definitely some pretty darn exciting things that I guess I can say I didn't expect to see coming. I was so surprised that I had to refresh the Visa Bulletin twice and double check to make sure I'm on the right month and the right chart, just to make sure that things were as I expected them. And on that note, I'm going to pull up my notes here on the subject of the old July Visa Bulletin, just so I can keep them up on the screen here and keep you guys informed of what's going on here. So I won't pussyfoot around the topic of India. India is, the most backlogged country, so I'll focus in on it first. A pretty darn big leap forward. These charts are the final action dates again for India EB1. India EB1 has gone all the way to 1st of February 2022. And where was it at on the June Visa Bulletin? It was a heck of a lot earlier than that. And again, I'm so excited I have to double check. It was way back in April 2021. We got the better part of a year of movement on this Visa Bulletin. Back in March 2021, we got the better part of a year of movement on the Visa Bulletin, which is pretty darn cool. EB2 India, we have movement forward from April 15th, 2012 to June 15th, 2012. Pretty darn cool. Positive movement forward on the Visa Bulletin for India EB2, about 2 months. Even EB3 India has movement forward 1 month from August 22nd, 2012 to September 22nd, 2012. I will take it. Same thing for other workers. 1 month from August 22nd to September 22nd. So obviously, on the Visa Bulletin, there was a lot of gloom and doom in terms of, on the end of it last month, talking about retrogression. But that was retrogression for the rest of the world. In India, the most backlogged country, especially in EB1, has seen a great big push forward. Pretty exciting time to be in the EB1 category, and I should know because I had some people who were working on that for. Fantastic. China got some movement forward as well. EB1 China, 2 months forward from 1st of September 2022 to November 2022. EB2 China, a month from February 2020 to March 2020. And EB3 and other workers for China stays the same. Rest of the world this is where we knew sort of the badness was coming. Here's where we hit with that. So there it is in the chart. Rest of the world, EB1 maintains current, because that's a pretty rare category for a pretty unused group of people. But here's where things get, actually, they still look pretty good for EB2. EB2, rest of the world, goes forward from January 15th, 2023 to March 15th, 2023. 2 months. I'm sure that's going to excite many people out there. But here's where the bad part is. We lose on EB3, rest of the world. We go back from November 22nd, 2022, all the way to December 1st of 2021. we lose about a year on EB3 rest of the world, a huge amount. And other workers for rest of the world have lost a little bit of time as well, from 1st of January 2021 to October 8th, 2020. Not actually, I've got that flipped around in my notes here. It was on October 8th, 2020, and now it's at 1st of January 2021. Actually, pretty good. So EB3 rest of world takes a great big punch to the gut, where everybody else moves forward. And I guess what we can say here is we knew this to be coming because the Department of State told us about this either on the last visa bulletin for June or maybe one visa bulletin before that. But it's been warning us for a while that retrogression late in the year is possible. And fun fact, July visa bulletin is late in the year, and here we are. So here's what it says on the visa bulletin. I have it on June 2024. Here, move it back to July. Visa Bulletin for July 2024 says the following regarding retrogression in the employment-based third preference. As readers were informed as possible on the item D of the June 2024 Visa Bulletin, it has become necessary to retrogress the worldwide EB3 final action date, including Mexico and Philippines, effective in July. Given continued high demand and number use in this category, it will be likely necessary to either further retrogress the final action date or make the category unavailable. That's when we would report you on the Visa Bulletin in August. This situation will be continually monitored and any necessary adjustments will be made accordingly. So I guess maybe we sort of spend a little bit of time talking about what this Visa Bulletin means for a second. Why is it interesting to me? Why is it interesting to you? Et cetera, et cetera. And obviously, if you guys have a commentary on it, I will be commenting on your commentary during the back half of this presentation and also answering all the usual questions. So for me, this Visa Bulletin is very interesting because, frankly, I did not anticipate a great leap lurch forward on India EB1. Such an exciting category for me. Always seeing those final action dates just make a great big leap forward there. For me, that is the big news story of this Visa Bulletin, EB1 India. EB3 rest of the world, we sort of saw it coming. EB1 India is a huge movement. And honestly, I think based upon the fact that the rest of the world is seeing, such stagnant movement, or in the case of EB3, movement backwards, I think we're sort of programmed to not expect much great movement on EB2 or EB3 in India, the most backlogged country. But again, per my notes and as I'm reading them, we got positive movement there. It's sort of interesting about what does this mean about how the Department of State views the Visa Bulletin and how they're able to calculate it. Because they gave us no forewarning about India EB1. I guess maybe we could have maybe had a guess by virtue of the fact that EB1 rest of the world is current, thereby it pushes visas into the EB1 India category. But the bottom line is, again, we're still seeing pretty decent movement in EB2 India, EB3 India. And when I think about this, it makes me think about how good a handle does the Department of State have on what's in the queue, who's in the queue. And what they're telling me for EB3, if I don't know, as I see the Visa Bulletin and how the government should work, they should be issuing visas to people across the year. It has got to be misery for USCIS and or the Department of State to be issuing visas, issue all your visas in the first quarter or the first 2 quarters. They have an entire year. Ideally, they would want to spread out their visa issuance, their visa usage out across the entire year. And essentially, what they've done, they've told us in the EB3 category, they said, we've worked too fast. We've kind of left ourselves without anything to do in the EB3 category for the rest of the world for the last, July, August, September, the last quarter of the fiscal year. Meanwhile, for India, country with some of the what I would presume are some of the most complex visa calculations, they're able to move it forward. I guess that means if they're moving forward in July, it means they have a pretty good handle on what they have in their inventory and the amount of time they have left to approve, green cards left in the year. So I guess that's sort of my big talk on the July visa bulletin. Something I'm pretty darn excited about, obviously. Just remember, big news, unexpected as I see it. India EB1 movement forward, which is great for those people in that category. If you've been thinking about talking about getting into the EB1 category, or just thinking about seeing if it's possible, it's pretty darn attractive. There are just a lot of people who could really kind of move up there. It's just such a short time. It's as short as it's just short. So keep your commentary coming in on the visa bulletin, because remember, part of our presentation here in the back half of what we're talking about now is to sort of take your commentary and your questions that come in. But I did have a primary topic. We sort of had a late-breaking visa bulletin today, obviously. I think it may have been posted in the last couple hours before this presentation began. But I did want to talk about my other main topic of the day, which is just sort of a topic near and dear to my heart. So if I want to do a public service announcement, is the trends in H-1B stamping. And I think the number one thing that people should know about H-1B stamping right now is that Department of State, the folks who handle your visa stamping application, is they sure are doing the job that USCIS is not allowed to do. They are investigating H-1B visa applications where USCIS, for a bunch of policy reasons that I won't get into, hasn't really had the time to do it. In this modern climate right now, if you ask me, Brian, will they approve my H-1B visa? And my answer to that one is my H-1B petition, rather. Do you have an H-1B job? Do you have the right degree? Yeah, you're probably going to see your H-1B approved by USCIS. But Department of State is another question. Basically, Department of State for the last really kind of 2 or 3 years has been very concerned about verifying the work that you're going to be doing in the United States. And to compare that against USCIS, for the last couple of years, due to policy reasons, USCIS has been told, nah, you're not going to be investigating client contracts, work orders, whether the work that's said to be in the H-1B petition is really available, whether somebody's actually receiving that service. But the Department of State has no such limitation upon themselves, and as a result, they are, if they have questions and concerns about your work while you're going for stamping, they're going to ask about them. And I guess maybe what I wanted to talk about was how can we prepare for that? Number one thing for me is consider filing an H-1B amendment. Those of you who've been for stamping at any time recently, or been for stamping at all, in case there's any people who haven't been to a consulate for H-1B stamping, the Department of State should have access to a copy of your H-1B petition when they are at the consulate, when they are reviewing and considering your visa application. And one thing that still can concern them is if your H-1B petition does not line up with what you're telling them at the consulate. If you're telling them at the consulate, yeah, I'm working for client XYZ, and your H-1B petition says, so-and-so is providing services to client ABC, those issues can still cause problems for the folks at the consulate. So I guess the first sort of layer is consider filing an H-1B amendment if you have the time and you're planning to go for stamping. Just because you have had a change in client within the same MSA, for example, that wouldn't necessarily be a reason that you should require an H-1B amendment. But the bottom line in my book is that it can be very useful, and sometimes a fresh, shiny H-1B petition can help the consulate to understand what you're actually doing, and thereby sort of turn down their anxiety about approving your visa. Fundamentally, on that same note, making sure your H-1B case is up to date when it comes to stamping. What you should definitely consider is having documentation ready about that. The classic H-1B visas kind of things. client contracts, client work orders, client letters, vendor letters for everybody down the line, assuming you're an IT consultant, because they will be. There's a good chance they will ask about those things. If you're not an IT consultant, honestly, it's letters of confirmation from your employer's HR team saying, here's what so and so is doing. Here's what so and so is a software developer for our company working on the X project, which is internal to our company. Thanks a lot. Goodbye. Having good documentation at the consulate, having the support of your company, or if you're IT consultant, the end clients and vendors you're working with can give you a better chance of success, because what you really kind of desperately want to avoid is a 221G situation, because it takes them a long time to resolve those things. They have discretion. They have the power to take a long time. And it can really screw up your life in the United States if you are waiting on something like that for a long time. If you can't come back to the United States, clients can lose interest, employers can lose interest, and suddenly you're out of a job and you're kind of back at square one. On the same note, in terms of preparing documentation, the good folks at the consulate have been known to call vendors, clients, employers to verify that the person they're meeting at the consulate is really is being truthful. So expect and warn people that have an interest in your coming to the United States. They may get a call. If you have a manager at the end client, for whom you're submitting a letter, let them know they might hear from the government. Please give honest answers. Please respond as soon as possible. It might impact me getting a visa. Same thing with vendors you're involved with. Same thing with your employer. Because believe me, ask me how I know. The consulate will contact people and ask them about H-1B stamping applicants. That is for sure. So many people have just jumped in and joined us. We have been talking about the July Visa Bulletin, a very exciting one where we've seen the India EB1 dates do a great leap forward about a year. Stick around. We're going to be talking about that more, I suspect, as we get to the back half of this presentation, where I take questions from those in the audience and, give my insights and thoughts about the future. Generally speaking, coming back to the topic of those investigations, the reason why you really don't want an investigation, because even a good investigation by the Department of State can take a long time. And again, even if you have everything in order, it is a punch in the gut if the Department of State wants to investigate your case, because they are government, they are slow. It will take them a while to actually, okay, we want to go ahead and contact, John Doe's H-1B consulting end client and the vendor company and his employer. They move slow at that. And, all those people, let's say it's, your end client or the vendor company, not even your H-1B employer, those responses usually are going to have to go through their legal counsel, something like that, and that can take time. They are going to be hoops to jump through. And if they don't respond at all, even, I mean, that's the sort of thing that can, obviously that'll be negatively impactful, but it takes time for the government to do investigations. And, there's that. Heaven forbid the investigation, doesn't go well. What you really don't want to have, this is sort of the bad news I had to give somebody sort of time. If things go bad at your consulate appointment, you kind of end up in a limbo. Well, they're not issuing you a visa, but my H-1B petition is still approved. How does it go forward? Typically, they will send the consulate, if they're unhappy with you, if the consulate says, hey, this guy or gal that I met at the consulate does not align with the person that I saw on paper in the H-1B petition that USCIS approves. So the Department of State will send that back to USCIS, and typically USCIS will issue a notice of intent to revoke. And that process can take like a year. All the meanwhile, you are sitting, in your home country, be it, India, China, or wherever you're from, and waiting upon, the consulate, upon your immigration counsel to resolve that with USCIS, hopefully in your favor. There are strategies to avoid that. What one might do is to, if you think a bad case of the consulate, in theory, you could file a new H-1B case to replace it and go for stamping based upon that. If it's some sort of fundamental issue you think you can correct with a new H-1B filing. But having problems at the consulate is just such an unfun time. It really does ruin people's lives in the United States. And they are investigating these things. So, and I desperately want to get back to the Visa Bulletin and everybody's questions, but I guess I would say the following takeaways from, stamping trends at the consulate is be prepared, file amendments if you can, have good documentation because they are investigating. And any sort of investigation can really, really screw around, and do everything you can to avoid it, because if you can't, it's just bad news for everybody involved. So, if it's not clear at this point, I'm extraordinarily excited about the July visa bulletin. I think I was expecting a dud, and I was very excited when I got my notification on my phone that it was out, and all the things I saw were just sort of awesome. So, speaking of that visa bulletin, I bet you guys have some commentary as well, and I am going to talk to you about it here and answer the questions that you post to us in the chat. Keep in mind that, frankly, really don't know much about your personal immigration situation, and the answers that I give here should not be taken as legal advice. Fundamentally, if you have an important life-changing immigration decision to make, you should make it by talking to an immigration attorney of your choosing. There are tons out there. A fun fact about the world of immigration, I would say probably only about 10% of us actually do employment immigration. But really, head out there into the world of the internet, find somebody who really does employment immigration and knows it well. We're the sort of office who does, literally hundreds, if not thousands, of H-1Bs a year, depending upon the year. Find somebody who really knows employment immigration, who you can really talk to. Find somebody you like, and really talk to an immigration attorney of your choosing before making any important decisions, because the devil is in the details. Without further ado, though, I'm going to get to some questions here, and let's see what we get. So, from Raj's channel, I have to give some bad news on that one for Raj channel. So Raj is has a scenario that is an interesting one for sure. It's, hello, my priority date is March 15th, 2023, which is the cutoff date for EB2 rest of the world. Am I current? Will I be able to file my I-485? Thank you so much. So, lost myself. The general rule of the visa bulletin is your date must be before that date. So if your priority date is March 15th, unfortunately, Raj, your date is not. It is the same. So that's the big downside. But one thing I would point out that I haven't really looked at or talked about yet is the dates for filing. Dates for filing for let me see here, EB2 rest of the world. It is in 22nd of March 2023. So what I haven't looked up is to whether USCIS will be taking dates for filing or final action dates for the month of July. And let's see if it is right here. There's the adjustment of status filing charts, dates for filing. Oh, unfortunately, they're taking the final action dates on the visa bulletin. So that's a problem for you, Raj. You're very close, but unfortunately, they're not taking the dates for filing for July 2024. They are taking the final action dates. And again, if you're looking for that sort of confirmation of that resource, Raj, here's what they say about when to file. If the date on the chart is current or your priority date is earlier than the date in the chart, you may file your adjustment of status application. The problem is your date is not earlier, it is equivalent or equal to. So I will still choose to be excited for you, Raj channel, because you are so close. You are so close to being current, and that's always an exciting time. And if not now, I would be hopeful and optimistic that you would be able to get there at the beginning of the fiscal year coming up, beginning on October 1st. Crossing my fingers for you. So, from Sriva. On Green Card EAD, EB2, and EB3, can I self-sponsor using my spouse LLC, my dependent, and resign from my GC employer? I like your comment already, Sriva. There's a lot of things that rhyme, and things that rhyme amuse me. and resigned from my GC employer. Any potential issues? Do I need to submit I-45J now from my own company? A bunch of great questions here. So, one, just in case there's anybody in our audience who doesn't know, Sam and I are always happy to talk about it during this venue. You can change to self-employment when you file for your I-45. Presuming you meet other requirements, the big one being that your I-45 has been pending for more than 180 days, you are actually able to submit a Supplement J that ultimately will be your path to a green card through self-employment through your own business. Fantastic. Or it could be one owned by your dependent. And resigning from your green card sponsor employer is a potential thing. I guess what I would say about about changing to your own self-sponsored I-45, your own company sponsoring your I-45 is you kind of have to make sure it's done right. This is the sort of thing where I would say talk to an attorney about it just to make sure that your business is set up in a smart way. In theory, the government can issue an RFE towards that substituted green card sponsor and ask questions about, or just ask questions. And again, you'd want to make sure that they have a viable, plausible offer of employment. That you don't just have a company that does nothing. That can you document that company has work available for you, I guess, is one of the big questions there. In terms of when to submit that I-45J, there's a strategic question about that. There's no particular time that they demand that you send it, but they certainly will. They certainly can request it in an RFE. So one of the, generally speaking, I would say my rule of thumb is, even though technically speaking, they expect there to be lapses of employment. That's why I allow I-45 portability in the first place. Your best practice is to always have a job offer ready to go with a sponsoring employer for your I-45. It can be your company, but make sure that your company is set up right properly. If you're going to call it a duck, it should look like a duck, walk like a duck, talk like a duck, sound like a duck. That's the same thing as talking, but the government shouldn't have any questions about that company's ability to sponsor you, essentially. And part of that is basically making sure it's run in a professional way. The more you treat it, I have no doubt that talented people out there, especially so many folks in the IT industry, which is a lot of where EB2, EB3, India green card folks have their ability to create their own business that can generate lots of work for them. But doing it smart, having good documentation available in the event that I-45J RFE comes in is critical in my book. So I'm going to keep on moving here with a question from HF. I'm going to call HF. Hello, friend. Hello, friend. My EB3 priority date is matching cutoff date per July visa bulletin. Oh boy, what a rare occurrence. Two of these in one. My priority date is September 22nd, 2012. I guess that would put, go back to the visa bulletin here. September 22nd, 2012. Dates for filing, final action dates. I guess that would put you in India, EB3 or other workers. And the July cutoff date is September 22nd, 2012. Am I eligible or PD of September? I think I answered the question earlier when I was answering Raj Channel's question, but the priority date, you must be before the priority date on the visa bulletin to be able to file your I-45. So unfortunately, based upon what I'm hearing there, I don't think you'd be eligible to file I-45, and that is unfortunate. I can't help but notice and be surprised that that there's two people in our audience, in our chat, in our community here that have dates that align with the cutoff dates. One can't help but wonder if for any reason those might be, high perm filing volume dates. I could postulate a couple reasons why there might be high density of perm filings in there, perhaps due to the fact that prevailing wages may expire around then. But I won't try to apply logic to how the Department of State arrives on these dates. I would just state that big picture HF is if you are so close now, give it a little bit of time. They haven't had negative things to say in the visa bulletin regarding, the India backlog, that it can't move forward, meaning there's a good chance that you will see yourself coming current soon. You're just a day off. I'll call it good news you're so close, bad news that you're not quite there yet. A comment from Empire, really kind of about generally how the Department of State is acting right now. Department of State seems to be very conservative this fiscal year because almost all the final action dates pass the filing dates, which is a good thing. I imagine you're talking about, giving. Maybe I would need more context about what you're pointing at, Empire, but I guess I would say that my take on are they being conservative? I don't know. I would say that I don't think it's ever their job to be conservative. Their job is to be as accurate as they can, based upon the concept that we give these things out on a first come first serve basis. And I think they are required to be a little bit conservative, at least on the dates the final action dates, because if they go too far, they run out of green cards. And believe me, ask us how we know, because we've handled a couple cases where we get an RFE or more of a letter from USCIS on behalf of one of our clients saying, "Oh boy, USCIS really messed up here. We accidentally gave out a green card we shouldn't," and they will take them back. So if USCIS, I don't know ultimately who was responsible for in cases like that. Maybe USCIS made an error, or maybe Department of State pushed the visa bulletin too far forward. But I guess I feel very good about the way the India folks are. The India dates are moving, because as I view it, Sam, I think, used this metaphor a couple months ago. It's sort of like you're at the gas station pumping gas. If you're going for a real accurate stop, I think you try to taper it off at the end. You don't. I think you're a madman if you plan it so you're going full blast until the last day. You sort of keep the flow moving until the end of the year, because that seems just smart in terms of evening out your workloads, that sort of thing. So keep going up keep it up in the commentary, Empire, if I've totally missed the point of what you're asking about, but I'm giving you some response. So next on, we're going to move on to Santosh here. Hi, Brian. Hello. Can you please help in understanding meaning of case status fingerprints relating to your Form I-485 application to register permanent residence adjustment of status receipt number MSC XXXXX? Does that mean fingerprint screening already completed, or it is in process? So I guess I'm going to put the main question up here. What can I make of that? So maybe I'll before answering your question directly, Santosh, I'll take a step back and give you my general and personal opinion. Others may vary on the USCIS online tracking. My answer to that would be, 95% accurate. Sometimes there are wacky statuses on that online USCIS tracking that just don't make sense. I would question, whether or not that message that you're putting up here for me is complete, because fingerprints relating to your Form I-485 case number this, what? Is there an end to that sentence? I don't know. But with a case status like that, I would kind of presume that you're early in the process. But I guess I would say, don't really, if you're trying to sort of mentally track where your I-485 is going within USCIS, I would say don't hang too hard on those status messages that you see from USCIS, either on the public tracking website or if you have a My USCIS account in their portal. They really don't often. The only real sort of substantive updates that I trust are if an RFE has been issued or if a case has been denied. I think that USCIS, due respect to them, is still extraordinarily bad about giving people sort of up-to-date information about how my case is being processed, what they're doing on it. I have no doubt that they have taken your fingerprints at some point, taken biometrics, but I wouldn't really put much more thought into it beyond that. I would not try to make sense of that message. Sometimes, if the message does not make sense, you can call USCIS and maybe they will give you more information. But again, even if you talk to one of those people on the phone at USCIS, when you call their terrible 800 one, the okay 800 number, but the terrible phone system where it's very hard to talk to somebody, odds are what they're going to say is all I have is the information that's provided to me. I'm not the officer directly working on the case, and if there's an issue, they can put in an inquiry, but I don't think they would do that. I don't think you have a concern. I don't see anything about that message that would concern to me or give me honestly any sort of meaning there. So Sriva here comes back around with a sort of a part two of a question that was a little bit earlier, because Sriva was asking about basically, I lost the question there, about changing to self-employment with a pending I-45 when you have a green card and EAD. And one of those great things brought up about, making sure you have a full conversation with an attorney is one of the things I didn't bring up earlier is you must be going to work in a same or similar occupation. And there's some interesting aspects of that, with an LLC that is sort of family owned. Can you be the president and CEO of it? I would argue that maybe you shouldn't be, because, if your labor certification 9140 was done as, a software developer, computer systems analyst, solution architect, database administrator, whatever, that could be a bridge too far from the president and CEO of, a company that provides, IT services. But getting to your question here, part 2 of 2, if an employer is ready to hire me, same or similar job in the future, will that suffice to be self-employed on GCEAD? When date comes current, do I need to submit supplement J? So, well, self-employment, that wouldn't be considered self-employment. That would be considered, in my mind, employed by somebody else, But let's maybe talk for a minute about, taking advantage of the portability rules and the narrow issue of supplement J itself. My best advice I can give to anybody when it comes to portability rules and talking to your employer about it, somebody who you're thinking of joining, is bring it up early, because there are companies out there who turn white as a ghost when you hand them an immigration form, even if it's a very simple one like supplement J. And in theory, you could find yourself in a world where they're not willing to, sign off on that form before you, and that could put you in a bad situation. If you're entrenched in the company, you get that RFE from USCIS that says, "Hey, we just want to confirm you have a job available. Give us a supplement J from whoever you're working with." That could be a problem if you march into the HR office and they say, "No, we're not doing that." I think your smartest business is to bring those things up when you're joining a company and get one as soon as possible and submit it as soon as possible. When the date becomes current, do I need to submit a supplement J? You probably, I guess I would say is, again, government policy, unless they've changed it very recently, doesn't tell you exactly when you have to do it. But I would say when your date becomes current, there's a pretty darn good chance that USCIS issues an RFE requesting supplement J. I just resolved one of these RFEs a couple weeks ago. Basically, your case has been sitting on a shelf collecting dust with USCIS since it was filed back in, October 2020, sometime in 2021, 2022. You get the point. It's been out there for a while. And that officer is going to get your case, blow the dust off it and go, do I feel comfortable doing this? Do I believe this job is still there? And if they want to brush away their fears on that subject, they will issue an RFE saying, hey, give me a new supplement J. I do wonder whether or not somewhere in government policy that we don't know about, whether USCIS anywhere out there says how long a supplement J has a shelf life. Hypothetically, you could hand in a supplement J, on October 1st from company ABC, right? Change employer, something happens. You change employer a month later, and USCIS would approve your green card case based upon that. And well, I guess they should have, if they wanted to make sure you had a job, issued another RFE for a new supplement J, but they didn't. You got your green card. Great. I guess, when do I need to submit a supplement J? I'd say before your date becomes current is sometimes a good idea, because it's a way that some people sometimes try to avoid that RFE where they basically say, hey, we got your case, we're ready to go, but we need a couple updates from you. I know somebody who even might be in our audience right now just sent me one of those RFEs before I went live here. He's had a pending green card for probably about 2 years, and my date's current. I just got an RFE, and I expect it's going to be that sort of thing. Give us fresh medical exams, that sort of thing. So my thought is, when the date becomes current, you should be prepared to have a supplement J available. Kudos to you. If your priority is about to become current, you might be able to send them, the things necessary to update your case, being like a medical exam and a supplement J, to get ahead of the curve, and basically, send them a letter saying, hey, I just became current. I'm just about to become current. Here's a supplement J. Here's a medical exam. You'll be able to approve my case. Here's everything you need to do it. No need for an RFE. Please do it. Something to think about there. Ooh, a great question from Empire regarding something that is on my mind and hasn't been something we've talked about too much. I guess we talked about H-1B a little bit here as part of, one of the main topics I wanted to hit. But how is the current H-1B filing for this year? Is it high or low second lottery? So, obviously, I have anecdotal evidence from some of our clients here, and I can tell you some of them are saying, the economy's not as good as we thought it would be. We're not going to be filing as many cases as we thought. And every case that isn't filed is tick in favor of an H-1B lottery second round. And I know there are certain people out there that are, hoping and praying for that. But one of the things that sort of discourages me on that front is how many H-1Bs they select versus how many they actually have visas available for. So think back to your H-1B knowledge. H-1B, 65,000 in the regular cap, an additional 20,000 under the master's cap, 85,000 visas, right? How many registrations did they select for fiscal year 2025? Get your guesses in right now, because I'm going to tell you what it is, because I pulled it up when I was talking there. They selected 120,603 registrations for fiscal year 2025. So that is a big difference. This is about 35,000. About 35,000 additional ones to account for denials, people that don't file, etc., etc., etc. So I don't have the means to predict how, whether there's going to be a second lottery, but I guess what I would say is that there is a big distance between 120,000, 35,000 is a lot of not filed H-1B caps. I've asked the opinions of people in our office here, and they've said, yeah, I think, we're looking at a second round, but all bets are off. And I guess what I would say is, you can be sure that me and Sam, this one's me, I'm not going to do a puppet for Sam, will be here talking about it, because that'll be huge news, life changer for some people, that's for sure. Here we are, going to move on to the next one from Hari. From Hari, I have filed H-1B, H-4, and H-4 EAD extension in premium, and our H-1B, H-4 I-94 is expiring on 31st of August 2023. My H-1B approved, but H-4 and H-4 EAD are still in process. Can the dependent on the H-4 travel outside of the United States? So this is the sort of thing where um, if it was filed with an H-1B, I would bet it was filed with an immigration attorney, Hari, and that's the sort of thing where I would kind of defer to tell you to talk to you about have. I would recommend have you talk to your existing immigration counsel about that, because there's a lot of facts here that I don't have. I can tell you in very broad strokes that generally that an H-4 and EAD change of status, if you have a change of status pending and leave the United States, that will cause it to become abandoned. If it's an H-4 extension, generally speaking, travel outside the United States will not cause an extension of any sort to be abandoned. Only travel. Again, the general rule they teach us immigration attorneys early on is change of status, travel, abandonment, extension, travel, not abandonment. However, the thing you have to be careful on that scenario, Hari, is that you might get some weird I-94 results when you travel with an H-1B with a new H-1B approval notice with that H-4 and EAD extending. Essentially, and this is definitely not something I want to get into during this talk, it's the concept, the idea that you're going to have sort of multiple, your wife, let's say hypothetically, she travels outside the United States and enters the United States while her H-4 and EAD are still pending. She'll have a new I-94 from Customs, but then there'll be another I-94 that'll eventually come in from USCIS, and some thought needs to be put in about how those things interact is the bottom line. And that's the sort of thing where I would usually have even though I usually say things in funny ways, people tell me I'm very good at explaining that scenario and how it works out. That's the sort of thing that I think you should probably talk to an attorney about it. I don't think big picture. I think I'm not really desperately worried about your wife, but I cannot give you that definitive answer of can't you travel without causing things to blow up, without really talking more and understanding more what's going on. Hope that helps. I'm sorry I can't give you a definitive answer, but I guess that's the sort of thing for which it brings up my sort of disclaimer here, as we always do for one of these sessions. It's very hard. We only have limited information about you. We're not in a real conversation here. We're just sort of taking questions as they pop up from YouTube as well as Facebook and other sources. Nothing is going to be a good conversation with an immigration attorney because, of course, it's not. Gonna keep it going here. Question from Ajay. Ooh, hi. Hello. Last day with Company A on June 15th. Priority date September 25th, 2012. I filed I-45 in 2020 under EB3. Interfiled to EB2 in 2022. Am I eligible with EB3 with my new employer, or my portability is only to EB2? Oh boy. So a really great question, Ajay. So there are, when it comes to, and I'm going to put Ajay's question here. I have no choice as I'm laid off with Company A, so my last day is this week. I'm sorry, Ajay, to hear it. But I will try to give you some general direction on this as to my take on this, which is pretty conservative. So you have EB3 and EB2 I-140s pending, and the last thing you did is a transfer underlying basis request. If you read the USCIS policy, lots of people love to call it interfiling. If you read the USCIS policy, they generally refer to it as a transfer underlying basis, changing what's propping your I-45 up, being you move from the EB3 I-140 petition to the EB2 I-140 petition in 2022. My conservative answer would have to be that you are likely stuck in the EB2 category, and I will tell you why. Because the changing of categories is basically saying, hey, swap in a different I-140 for me. transfer me from this I-140 to this I-140. The problem is that to swap to that new I-140 requires your I-140 employer to be involved, and that I-140 employer is out of the picture, essentially, as you're explaining, because you're about to lose employment with that company. So there are people out there who advocate just sending in the supplement J and seeing if sending in the supplement J and sending in a letter saying I'm moving back to EB3, and just seeing if you get away with it. And I think you might, but I definitely cannot recommend it, because as I read the government policy on what is transfer underlying basis, you're not taking advantage of the portability. You're not moving to a same or similar occupation, because the same and similar occupation can take you anywhere you want. What you're asking for in a transfer underlying basis is to move me to a different I-140. And you can't move to an I-140 if the employer behind that I-140 is not supporting that offer of employment anymore. And that's the problem I would have with that. So I would say that my logical answer, if immigration law works in a logical way, would be that you would be in the category that you last transferred to, essentially. Now, the impact of that would naturally be that if you have a September 25th, 2012 priority date, you are let me see, final action dates for employment base for July. You are so close in EB3, India, and you are maybe a couple more months off for EB2, and that's the big bummer there. But I would say, well, you don't have no action you can take right now. You're not current in either of those categories, and I would just say let's cross our fingers for the October visa bulletin, because you are so close. Yeah. From AK. My priority date was current till today. It is now retrogressed. Can I still expect any updates in June? So I will fight with you, AK. Your priority date has not retrogressed until July 1st. The visa bulletin for June of 2024 is still a good visa bulletin. In theory, the reason for retrogression in July should be that we have enough cases with priority dates that are current for June, such that we can all approve them all and give green cards to those people. Meaning, it's still possible that they could have a visa available for you. If they didn't think they'd have visas available in June, they would have retrogressed in June, is my optimistic view of this scenario. It's still possible. The more pessimistic version says, I would definitely wonder if the government, even if they might have visas available, whether they lose motivation when they know a retrogression is coming imminently, I guess, is the bottom line, is the alternative take on that. Have you successfully done self-employment GC conversions from main employer to self-sponsored GC? Yes, for sure. Bottom line there. Yeah, it's the sort of thing that just takes a little bit of time, takes a little bit of planning. You can do it. From Empire. Empire always has some good commentary for us. The date said in October for filing dates, to expect the dates to be at the end of the end of it. I see. It changes more than once this year. That is not common. I think this goes back to Empire's sort of prior conversational point. It's, where do the filing dates start in October, and where are they now? And I guess you're pointing out that they're sort of moving as they expect, which is, good. Let's see here. Ajay Shah. Can a new employer use EB2 or EB3 date for I-45J? Since my EB3 is tied to an employer and I am EB2 lane as per my last interfile, are there any options for my new employer to use EB3 date? I think this is fundamentally the same question that I had asked. Because it's the same question from you, Ajay. I think I answered that question earlier. And the answer is no, unfortunately. I don't think that scenario works. But you sort of have a follow-up question, Ajay. Can I ask my laying off employer to interfile to EB3 before my employment ends this week? I doubt they will do it. I don't think you can. Well, I don't think you should. I don't think they can in good faith. Why? To sum up that supplement J form, it's a two-part form. It's you saying, holding out your hand, saying, "I'm intending to take the job offer put on this I-45J," and the employer saying, "Here's my offer on the back half of 45J." I really want this to look better in front of me, but it's not working. And somebody can't make. I don't think either of you guys could sign that form in good faith. Why? Because the employer knows they no longer want you on a permanent basis because they're laying you off, right? I guess there's an outside chance that the layoff is temporary and they are willing to bring you back as soon as the green card's available, but it doesn't sound really plausible. And you know, if you know that they don't want you back, you can't really sign that form in good faith saying, "I'm intending to take this job," because you're not, you know? I mean, I'll give my public service announcement on this front that the number one thing where sort of people get in trouble in immigration, I don't think anybody in this audience would really do that, but it's when you are untruthful with the government. Sometimes having problems in your immigration history isn't really a problem, but when you lie about it, that's when it really makes things blow up with the government. Good commentary from Empire against. And again, I know it's not perfect science because it's the best guess based upon information on hand. If they were able to be more liberal when setting the filing dates, those two individuals could have filed. Yeah, that's filed back in October because the filing date would have advanced more. And this is Empire is something, we don't really talk about it, too much on this venue live here on YouTube. It's something we sometimes bring up in the office here, is that visa bulletin date politically, set? And the answer is, is there any political? Yes, there has to be. I think if you replaced who was doing that, you would get somebody with, let's say, more conservative immigration beliefs with more conservative immigration results. Again, if I had my druthers, I would say they should basically take cases once you have an approved I-140, essentially, or maybe after a couple years, take a case just and let it allow it to be pending, because I know of so many people who would be just super thrilled to be relieved of the anxiety of, I want an H-1B visa. I have to work. The best I can hope for if I lose my job is 60 days to get a new job. Otherwise, I'm in serious trouble. Having that work authorization or even just a travel document, just that travel document is rough. That's 100% for sure. There's so many people who are so stressed out about stamping, for example. But I want to keep on moving on here and just try to get through these questions as I'm coming up on the hour here. From Rahul Sarkar. I worked in the U.S. from 2011 to 2013 on H-1B, but after that, got transferred to a different country. I quit my job in 2015 and came to the U.S. for grad school, and I'm currently on F1 OPT after graduating. When I got my F1 visa in 2015, the officer put a "canceled without prejudice" over my H-1B visa stamp. If I apply for H-1B, will I be able to capture time, or will I need to go through the lottery again? I would give a high likelihood that you would be able to recapture that time. The bottom line is they have pretty much clarified that recapture, once you've been on H-1B status, the recapture is pretty much infinite. And there you go. I guess if I were filing this H-1B for one of my employment-based clients, I would probably let them know that it's a little bit old, but it's definitely a case worth filing. Obviously, do it at a time. Do it at a time before you need it. Obviously, if the government tells you no, you want to find yourself in a spot where you have time to register yourself in the lottery for the next year. But a commentary on canceled without prejudice. Without prejudice means canceled and we're not holding it against you. You didn't do anything wrong. You can apply for a new visa in the future. That's only regardless to the visa stamp. But again, this is a scenario where there's a very good chance you'd be able to change back to H-1B status because you have, based upon the math, you have about 4 years left. There you go. You only used 2 years. You're good. A question from HF. My medical was filed with I-485 in 2021. It's expired now. When my priority date becomes current, can I take medicals and submit without waiting for RFE on medicals, or wait until USCIS requests? So basically, USCIS, if you still consult the I-485 filing instructions, I guess I haven't looked since they updated the forms in April on April 1st, but historically, in the I-485 green card application form instructions, they have said, yeah, we'll take those medical exams in any time. But I figure it doesn't hurt to see what it says. Here we are. Form I-45, show they're free. It's not if you're applying for only U.S. says, here we are. Here's what it says in the current I-485 instructions regarding medical exams. You are not, that's capital letters, bold text, not required to submit Form I-693 at the time you file your adjustment application, but may do so if you wish. Because of the time-limited validity of Form I-693, you may choose to submit your Form I-693 after you file your Form I-485. You may also submit Form I-693 in person at an interview in a USCIS office if an interview is required. By waiting to submit Form I-693, you may avoid having to repeat immigration medical examination. Now, this is very funny, and this is the April 1st, 2024 edition of the I-485, where I guess this is one of those things where the left hand of USCIS does not know what the right hand of USCIS is doing. And I will admit that this one is actually my right hand over here, and this one is my left hand. It's all confusing on video. But they're still saying, hey, your medical exams may be expiring, so you may not want to submit them initially. And but what it says, if you go to the Form I-693 page for USCIS, they have a notice on the top there, which we brought up here before. It says, effective April 4th, 2024, any Form I-693, that's the medical exam, that was properly completed by a properly completed and signed by a civil surgeon on or after November 1st, 2023, does not expire and can be used indefinitely as evidence to show that the applicant is not inadmissible on health-related grounds. So, to come back around and answer the question, the form instructions say you can submit them at any time, even right up until an interview. Fantastic. A while back, they had submitted the policies, made a policy statement somewhere saying, don't send us medical exams. We're going to get lost and confused. I haven't heard them update that policy. I got to presume it's done. I have helped people fairly recently submit unsolicited medical exams and have had no problem. It's gotten to people with some green cards faster than they might have gotten otherwise, we think. I think your conservative thing to do is this. Get 2 copies. One, submit to USCIS along with anything else that you might need to refresh your files, such as a new I-485J, for example, and keep another copy around. Pay the doctor for 2 copies. Why? Because just in case they lose it in transit, you get that RFE. You have another copy of the medical exam. As long as it's dated after November 1st, 2023, you're golden. We have one more question here. I realize I skipped over one. And maybe it's because in my mind it's a family-based immigration, but I will take us a moment to sort of talk very briefly about family immigration. So we do that too around here. Can you file Form I-130 a month prior to getting married? No. Unfortunately, you cannot. I-130, for those who aren't aware, is the family-based path of immigrating to the United States. For example, a U.S. citizen who marries somebody who lives outside the United States or is just a foreign national might file an I-130 to get USCIS to understand that a couple is husband and wife, and the whichever one of them is the foreign national should immigrate to the United States. It is the family-based cousin to the I-140 petition that we're usually talking about so much in this venue. And in the world of immigration, there's a concept called eligibility at the time of filing. And the problem you would have with this scenario, question asker Shonda, is that you, at the time you file that case, you would not be eligible because you guys would not be married. You must be married before you file an I-130 petition. And you would hit some obvious problems, even doing the form, because on the form, they ask you, well, what's your date of marriage? And you put a future date. You're probably going to get a request from evidence about that, saying, hey, you have to be married before you file this thing. And when you can't produce that evidence that you're married before you filed this, the government is going to one, eat up your filing fees, which I think are now $675 for an I-130 petition, not an insignificant sum of money. And you're not going to get that money back. They're just going to put it in their government belly and say, that was delicious. Thank you for your money. And file another I-130 actually when you're married. And that's really kind of the end of it there. So file your I-130s early. And for those of you who haven't achieved, permanent residence or citizenship yet, I look forward to filing an I-130. It's very popular to do. For example, if you become a permanent resident through employment, you eventually become a U.S. citizen. Sponsor your parents when you're become a U.S. citizen. If you want them here in the United States, it's a great way to get them here. So it is 7:06. I think I've gotten to all the questions that are live here. I will thank everybody so much for tuning in and joining us today. I will wish everybody an absolutely fantastic week, but I'm going to complain about this week for a minute. I'm here in fabulous Columbus, Ohio. It's 65 degrees today. It's June. It's supposed to be summer. What gives? I don't know. But I'll talk forever if you guys allow me to do so. And I will see you guys next week. And I wish you all a fantastic week. Goodbye now.